Morning, everyone.
Morning.
Ms. Whiteside, are you ready?
Yes, sir, I am.
All right, this is a hearing on the defendant's motion to strike the plaintiff's designation of expert witness. And I'm also aware that plaintiffs had filed a motion for continuance of the trial setting. Defendants have pointed out that that is not scheduled for a hearing this morning, but we'll deal with that problem as we go along. Is the movement ready to proceed this morning?
Yes, Your Honor. Good morning.
Good morning. Tell me how you pronounce your last name. Would that be Schiffman?
It's Schiffman, yes, sir.
Very well. Mine's Delaney.
Thank you.
And Mr. Bryant for
Yes,
the
sir.
plaintiffs. Are you ready?
Yes, sir.
Okay, I have tried to carefully digest the motion to strike. I've also read the motion for continuance. I'm struggling to understand the docket control order that apparently the court generated on its own motion on September the 7th. But I have all the documents available to me here on the screen of another computer so I can access them. Let me give both of you an opportunity to make your oral presentations and we will sort this out. Ms. Schiffman to begin.
Thank you, Your Honor. As Your Honor knows from the motion to strike, plaintiffs' counsel and plaintiffs have been late in serving every discovery response, and as shown by the exhibits, we have had to ask for service of the responses. Somebody missing a deadline once it happens, but continuously missing deadlines is inexcusable. And the expert disclosures required by Rule 195, that particular document has never been served. And I understand there's a distinction with the docket control order with an expert designation. The order says that doesn't substitute for Rule 195. So our motion is based on the fact that plaintiff was untimely, and by his own admission, by counsel's own admission, plaintiff's counsel was untimely by a quote calendaring error. There's tons of case law saying inadvertence of counsel, which I'm pretty sure includes a calendaring error, is not good cause. And since that's what he said has happened, that's not sufficient grounds to allow admissibility of this expert's opinions. And not just was it late, but it was grossly incomplete for, even if the designation that was filed with the court is considered an expert disclosures, it didn't have even a resume, not even a resume. We went ahead and proceeded just thinking, let's cover our grounds, our bases, and designated or served expert disclosures with every component of Rule 195. We did not do the expert designation. I'll just admit that to the court right up front, but we were timely in both. Our expert disclosures covered everything that would have been in the expert designation. And it was timely under either deadline, under either the DCO or under the Rule 195 deadline. And so because things have been late, we have been, Your Honor, just very understanding. Even with the first set of discovery, counsel asked for an extension and we gave it to him. Didn't argue about you've waived objections. We just thought, okay, we'll be understanding. We'll be cooperative and be, kind and so on. But then it happened again with the second set. And I just got, I think yesterday or maybe Tuesday, the response to the request for production that had been overdue by 2 or 3 weeks with no additional documents. They're going to tell you that there were no additional documents, but that's pretty questionable. And I know that's not in front of the court. As far as the continuance goes, Your Honor, it's put us in a position. We have pressed on this because of the continuous delays. And honestly, this is a legal malpractice suit, as Your Honor knows. Our clients are pretty upset that they've been accused of legal malpractice and sued for it. And plaintiff's counsel has continuously been delayed and made mistakes. And so that's really, Your Honor, where we're coming from. And the motion is, yes, technically it's late and the designation and it was incomplete, but also there's these other issues that just, it has to stop at some point. We can't keep reminding plaintiff's counsel, to serve things that he automatically has to serve under the rules and so on. And we don't think plaintiffs have met their burden of proof, as argued and as shown in our response to our reply to the response to the motion to strike. And we are, as Your Honor knows from our response to the motion for continuance, and again, we don't think it's properly before the court, but if the court's going to entertain it, then we want to make our argument, which is we don't think plaintiffs should get a second chance to correct the expert disclosures. But if Your Honor denies our motion to strike or grants a motion for leave and a continuance is offered, we certainly do not oppose continuance in the circumstances, because then there would be more needed to be done. Our expert wrote his or gave his opinions based on what we knew. It was only that a very generic statement that plaintiff's expert was going to say they didn't meet the standard of care, just period. No detail whatsoever. So we would obviously need time to deal with what has now been disclosed as of, I think, the 7th was an exhibit filed with plaintiff's motion and response.
Are you at your stopping point there?
Yes, Your Honor. Thank you.
All right, Mr. Bryant.
Judge, let me start by saying I regret that we're having this conversation. I can assure you, in 30 years of practice, this is not how my firm operates. But there's something that I have not put in my motion. I don't know that I wanted to put it in the motion, but the truth is, for the last 3 or 4 months, I have my legal assistant who handles all my scheduling, discovery, everything. And I've got 85 cases I'm doing. Her son has a very serious liver problem. He just got put on the list for transplants, and she's got an autistic son as well. So basically, I've had to take over scheduling and discovery, literally every part of that. So it is true, I was late on some discovery responses. I've provided those now. It's not that I'm trying to hide the ball. I have no motivation to hide the ball in this case. There's 2 basic issues. There's a right of first refusal that wasn't drafted properly that a court found to be unenforceable, and there's a conflict of interest issue. And if you look at their expert reports, same as my expert, he's based his opinions on the documents. Same thing with the defense experts. And I understand Ms. Shipman's position. This was not intentional. And in terms of good cause, I mean, Ms. Shipman's right. I've seen the case law. It says inadvertence of counsel without more is not good cause. So I'm not sure if the court would consider the circumstance at my firm as an additional element of potential good cause. I'll be honest with you, the case law says what it says. I've not been able to find a single case that says what that other thing might be without more, right? So in terms of, I'm sorry, oh, I heard something. In terms of lack of surprise or prejudice, the key word is unfair prejudice. No depositions have been taken. We're going to require more time. There's no way we're going to get all these depositions done before January the 10th. And so I'd ask for a continuance so we could at least finish the case. Yes, I made an error in calendaring, and quite honestly, Judge, I'm going to get rid of this thing and come up with a better system. But that's what happened. So I haven't intentionally been dilatory. I've just been totally inundated. So the discovery has been answered. I think under these circumstances, even if you don't find that I've met the burden on good cause or lack of surprise, will still allow you, in the interest of justice, and even Rule 1, the very first rule of civil procedure, states that the rules are to be liberally construed to achieve justice and fairness, etc. And you have the authority and discretion to do that. So my motion for continuance and late designation, I understand they weren't noticed on the docket, but it's part of my response. So I would hope that the court could consider that this time, even though it's not formally noticed for hearing. Let's see if there's something else I need to address.
I'm sorry, would you repeat your last point there?
The last point was even though my motions were not technically set for hearing, they are part of the response. Just as an example, if you file a response to a summary judgment and ask for continuance, that's typical practice, at least in my experience. So I don't believe that there is any unfair prejudice or surprise. It's clear by the expert reports that expert disclosures that the defendants have done is that they understand the issues in the case. I did a supplemental expert disclosure and I included it as part of my response to their motion. And I actually served a supplemental disclosure on counsel a couple of days ago, where I say, please see the report and resume, etc., of Michael Valentine. So they actually have that information. The simple solution where no one's going to be prejudiced, no one's going to be harmed, is to allow a continuance or grant my leave for late designation. I would propose that the designation that I provided as part of my response be accepted as a late designation, and that the continuance be granted. I offered counsel an extension on their designation as well. And obviously, counsel's indicated that if you deny their motion or grant mine, that they're unopposed to a continuance. And so, in all fairness, I have made mistakes and I take responsibility. I wanted to tell why that happened. It wasn't just something I let happen. And I would appreciate the court's consideration.
Your Honor, may I respond just very briefly?
Of course.
Your Honor, I don't recall receiving any separately served expert disclosures just 2 days ago. I know that there was a supplemental designation filed as an exhibit to plaintiff's motion that was filed, I think, on the 7th. But Your Honor, I also wanted to just say, if the court is inclined to allow plaintiffs to proceed with their expert, then we would just ask that the court do the same for us and allow us the opportunity to file. Our expert disclosures have been filed as an exhibit, but at this point, but just want to ensure that that is, if that's given to them, then we want the same opportunity.
Agreed.
So there's confusion in my mind about the impact of the docket control order and the impact of the discovery rules. How to read the two of them in conjunction with each other. And what effect, if any, that the intersection of those two sets of requirements has on the problem in front of me here. For instance, the docket control order says in paragraph 2 that expert witness designation shall occur in the case of the parties seeking affirmative relief by 150 days before trial. So if the trial date is March the 6th, when is that expert designation due? Is that October date or something else?
It's not the October 7th date, Your Honor. That was, as far as I recall, I'd have to pull it up, but I believe that was calculated by December 10th. And calculated backwards, I'm sorry, January 10th being the discovery deadline that we informally agreed to extend from December 6th. I can tell you this, I know that plaintiff's designation was not timely under either Rule 195 with the January 10th discovery deadline or with the 150 days out. Our expert disclosures were timely under both. And ours, the designation is, well, I don't want to repeat what Your Honor already knows, so I'll just stop.
Well, the only reason I'm using our time to discuss this is because it concerns me that in the court's effort to do a good job managing the docket, we may be inadvertently becoming more of a problem than an asset. So just to help me think this through, what's the easiest way to calculate what is 150 days before October 6th? I could do it by pulling up a Julian date calendar, I suppose. Mr. Bryant, you displayed some kind of wheel calculator.
Your Honor, I'm sorry to interrupt if I did just now. I've got there's a website, timeanddate.com, that I use.
Of course.
And it subtracts, so I'll do that right now.
Yeah, do that.
March the 6th, I'm on the browser right now. March the 6th, subtracting 150 days is October 7th, which is a Friday. Was a Friday.
What was the name of that website?
It's time and date. Yeah. Timeanddate.com.
I'm writing that one down right now.
It's a great site. You can calculate between days and add and subtract.
Thank you. Appreciate it.
Sure.
Everything's up to date in River City. So here at this computer, I cannot even print out a copy of the docket control order. That's a personal problem. I can get it on the screen. While I continue to mull all of this big picture, Ms. Schiffman, in your motion to strike, use a term called the discovery period. Where does that come from?
The Texas Rules of Civil Procedure. And from so the court said in the DCO, the discovery deadline for December the 6th. And then when plaintiff's counsel had said back like Halloween time period, I think we need a continuance. We said, well, it's still 4 months away, but we noticed discovery ends 90 days before trial. So let's move that. We can move that by a month, and we offered till January 10th. We never did a Rule 11 or anything, to be frank, but we're not necessarily, at this point arguing about that.
Okay, you equate the docket control order requirement that discovery responses to written discovery be due 90 days before trial.
Is that what it's?
You're making that the equivalent of the end of the discovery period?
Yes, Your Honor. I mean, maybe that's not what the court intended with that.
Maybe the court doesn't know what the court intended. But again, we've got these discovery rules that are fairly elaborate, and then we've got superimposed over that the the court imposed docket control order. So assuming for a moment that the court has the power to overrule the rules of civil procedure with its own local practice, when it signs a docket control order saying that the discovery responses are due 90 days before trial, and by that it refers to written discovery responses, does that include, what does that do to the rules of civil procedure requirement that a party provide an elaborate description of what the expert is going to say, a complete expert designation under Rule 195? Is that a response to discovery, or is that just something required by the Texas rules?
Your Honor, I would submit that it's kind of an oversight with the legislature that changed the rule in January 1st, 2021, because expert designation used to be a part of Rule 194.2 disclosures, requests for disclosure. And so requests for disclosure had a response. So that definitely fell under it. I would think submit to the court that the legislature just didn't think about that specific issue. And I believe that the expert disclosures are considered discovery responses still, even though there's no express request.
According to the new rule, the disclosure is required irrespective of whether there's a request.
Correct, right, Your Honor, but it was for 20 whatever years a response. So
okay, look, we need to cut to the chase. In your response to the motion for continuance, you say you're not opposed to the continuance, but you don't want that to affect your motion to strike the designation of this expert witness.
right, Your Honor, we just didn't want to waive that motion just right off the bat because he asked for a continuance.
It's not going to help him very much to get a continuance of the trial if his expert can't testify.
Well, that may be the case. And as I mentioned at the beginning, Plaintiffs' counsel has been late with every single thing. And Your Honor, I understand that, like I said, that life happens, but making us ask for initial disclosure, serving discovery before discovery even starts, making us ask for the first set of responses, asking for an extension, asking for word copies, then missing the second set of responses too, then not serving, saying we need the second set of responses by December 9th, and we just got the responses to the second request for reduction just a day or two ago with no documents. It's just delay after delay after delay. And Your Honor, really, we just need this to stop. And if plaintiffs have the burden of proof and they're prosecuting the claim, but they're not exactly pursuing it in a prosecution kind of manner, and our clients are just very frustrated with having a legal mount, being accused of making these big mistakes over which they've been sued. And then there's all these delays. It's just left them in a position of, well, gee, what are we supposed to do? Just continuously extend courtesies, continuously accommodate it. Some accommodations can happen, but not every single, not just constantly.
So I think I understand that you could probably have laid behind the log and waited till Lawyer Bryant called this expert at the time of trial and asked to exclude the jury and raised this objection at that point. And we would have all had some high drama at that point. Or is there some rule of civil procedure that says that you waive your complaint by laying behind the log like that?
I'm not aware of a rule of civil procedure on that, Your Honor. I know sometimes expert challenges have to be heard for a DCO by a certain date, but I don't believe that's the,
That seems to be under 702.
right, that's for like being unqualified.
Right.
Right, but that's as close to I know of a rule, Your Honor.
So you've done plaintiff's lawyer a favor indirectly by raising this issue when you did. But when we talk about good cause, there may be good cause to give plaintiff's lawyers some relief here when we look at the big picture, because if I don't give him some relief, that could very well result in another malpractice suit when his chief witness is excluded. And now suddenly the court system becomes burdened by that. Okay, so what I'm going to do is to dish up a serving of mercy as opposed to justice. And I'm going to grant his motion for continuance. But before I make that ruling final, I want to raise this question. I think it would probably be reasonable to require as the cost for this that lawyer Bryant compensate your side for the attorney fees that it's incurred in filing the motion to strike and having this hearing.
Okay.
Mr. Bryant, what do you say about that?
Well, Judge, I'm willing to do that. You know, and again, opposing counsel has been very accommodating. I agree. She's been very accommodating. I apologize to counsel in the court for having this hearing, but if that's what the court determines, that I need to compensate for fees for the motion and hearing, then I will do so. Could I make one more suggestion?
Absolutely, of course.
We could enter into a docket control order that has specific dates where we don't have these questions out there. And I typically practice in Harris County, and all the courts in Harris County, there's specific dates. But in Montgomery County, as I pointed out, there's some few courts that use this system of backdating. So I think that would actually be helpful. We won't have any more issues like this. And I don't know if opposing counsel would be agreeable to that or the court, but that is one solution to the dilemma that we're talking about today.
We can talk about that. Let's talk about this penalty that I think it's fair to require you to pay.
Yes, sir.
The ball is in your court for the moment, Ms. Schiffman, to give me a rough estimate, rough calculation of what you think it's cost whoever is paying your bills for the legal work that we described a minute ago.
Your Honor, do you mind if I take like 1 minute to look? Because I don't want to be like, I really don't want to overstate it.
Take your time.
Okay, it really will not take me a huge amount of time.
All right.
Your Honor, maybe I excused for 1 second.
Of course.
Okay, thank you. I'll be right back.
Yep.
I'm back, Judge.
And I'm ready, Your Honor.
All right, let's hear from you.
So, Your Honor, it looks like we have 5.4 hours in the motion, and then the response and the reply to their response. The response to the motion for continuous motion to late designate, and then the reply, which was all one document, was 6.8. So 12.2 total. And that excludes the hearing. When I had the 30 minutes that we've been, so I guess that's 12.7.
All right, your total billable hours are 12.7.
Yes, Your Honor, that's what it looks like.
And the rate?
That I don't have offhand, but I would just submit 225, 250 is somewhere in there would be our rate probably.
Is
So
that okay? Fair enough. I won't
Yeah.
comment. 12.7 times 225. And what does that work out to be? Do we need to go to timeanddate.com for that, or should we?
I can do it on the calculator. Hold on.
Oh, a mere calculator.
7.
I've got one of those too.
28.57.
28.57 5 and 50 cents.
It's interesting. I was just ballparking the figure of 2,500 before we started the discussion.
Well, pretty
So,
close.
Mr. Bryant, what's your response to the proposal that you reimburse them $2,857.50?
I'll do it.
How long will it take to do it?
When does the court order me to pay it? If I need to pay it today, I'll pay it today.
Are
tell
you
me.
capable? Are you capable of issuing the payment today?
Yes, sir.
Who should the check be made out to, Ms. Schiffman?
Your Honor, go ahead and make it to the firm just so I can, because that'll be easier. I don't know their name to pick right off at this point, so you can make it to Thompson, and we'll pass it on as necessary. Thompson Co. Cousins and Irons.
Or are you credited against the billing? One of the two.
We will definitely. I assure you, we will post it as necessary to compensate the client or
Okay.
the carrier.
All right. Mr. Bryant, I want you to issue a check in that amount and place it in the United States mail today to Ms. Schiffman's firm's address.
Yes, sir.
All right. Now we will turn to a date that the two of you can discuss with me right now about when you want to have this case set for trial.
I would
And
say
I'll tell
July
you-
or August.
While we're talking, I'll tell you that I like to set two trial dates, a primary and a backup. But both of them mean the same thing. The first one is the trial date, and that's when we're going to go unless a meritorious continuance is granted. And the fact that you have a backup trial date does not make it any easier to get a continuance from the first one. The whole idea to create a backup is analogous to using a shotgun to kill a moving target or what have you. This is shotgun trial setting to get this case to trial and concluded at the trial court level as rapidly as possible, so we don't have to reach out 6 months down the road. I want to get 2 trial dates on your calendars so that you don't say, oh, I'm already set, I can't do that. All right, first date. Ms. Shipman, what do you propose?
I would propose July or August, Your Honor. And
All right,
that's,
before we get into the weeds of the details, how does July sound to you, Mr. Bryant?
I believe that'll be fine. Probably one of the last 2 weeks in July, the 18th or the 25th. It's probably a 4-day trial, in my opinion.
17th and the 24th.
Oh wait, I'm in the wrong. Hold on a second. There we go. No,
This
yeah,
is 2023.
right, 17th and 24th.
And the 17th is a Saturday. Well, that's June. 17th is a Monday.
Either one of those 2 weeks. I mean, at this point, I'm pretty open. So either of those two is fine, or the first week of August.
July 31st is the Monday.
Right. Okay. So July 31st through,
Yeah.
and even the second of August.
How do you feel about July 31st as a first trial date, Ms. Schiffer?
They'll be fine with us, Your Honor.
And then the backup date.
You asking what we propose?
I am.
Okay. How about, and I don't know how close Your Honor wants to make it, but how about September 11? Well, I don't know that. Feels funny saying that number, like some kind of jinx, but if Your Honor wants it closer, maybe move up 2 weeks. I'm assuming Your Honor wants them somewhat close in time and not 4 or 5 months apart.
That's the whole purpose, of course.
Okay, so let me take that back and say September 25th. Because if we're going to ask for a continuance from July 31st, we definitely, if somebody does, chances are we'll need at least 3, 4, 5 weeks. And then there might be things in between those, other things that happen in those 3 or 4 or 5 weeks. So September 25th would be, I think, what, 7 weeks? It'd be 8 weeks. So maybe September 11th is okay. I would just submit somewhere in September.
And your position, Mr. Bryant?
That date's fine.
You're willing to go along with anything here today, right?
Well, Judge, I've got a completely open schedule, so I have no conflict at this point.
So you said September 11th, right?
Yes, Your Honor.
Now, okay, both those dates are fine, and I'm going to put them on my calendar. And before I forget to say it, now that you've got this new date, this primary date, July 31st, you better get your witnesses lined up and get them committed. Don't come in here with a motion for continuance on, middle of June middle of July saying, oh, my expert witnesses have got travel plans and blah, blah, blah. You get them coordinated ASAP. And if there's a problem with any of these dates, get with me to adjust the trial dates ASAP.
Okay.
I'm willing to work with you now, but I'm going to be a lot less willing to work with you if you haven't used a lot of diligence to make preparations.
Thank you, Your Honor, because I don't know my client's availability on those dates. So I appreciate that very much.
I get that. I get that.
Yeah.
So I'm going to let you construct your own docket control order in light of the changes to the rules of civil procedure. But the court has some useful things in their local DCO.
Standard form, you want us to consider that, Your Honor? Is that what you mean?
My comments go to things that are outside the rules of civil procedure. For example, she's got a requirement in here about a joint notice filing 14 days before trial.
Okay. We can build that in, right, David?
Sure. Like a pretrial order. Something like that.
Right.
As I read that here on my screen, I'm not so sure we shouldn't go ahead and set our own pretrial conference date today. What do you all think?
It's fine with us,
Because-
Your Honor.
A week out or 2 weeks out?
When is it usually? Oh,
I
the
couldn't
last one
I could not understand you.
I said, I'm sorry, Your Honor. When is it usually? Because I see a lot of pretrial conferences, maybe not Montgomery County, but that are the Friday, 10 days out, the Friday before.
Yeah, something around 10 days out, I think, is more useful to you. If it's Thursday before the beginning of trial, it's too late to be of significant value, I think.
So maybe July 21st.
And by the way, these would be by Zoom, of course.
Okay.
Well, July 21st is a problem for me because I have another pretrial arbitration that day. How about Thursday,
20th.
July 20th?
It's fine with us.
All right with you, Mr. Bryant?
Yes, sir.
Okay, 1:30.
Judge, I'm assuming we'll have a live trial and not a Zoom trial, correct?
The trial itself, of course, is going to be live, yes. Unless we have a COVID explosion between now and then. So September 11th being the trial date. How about August 31st for the pretrial?
Okay.
1:30.
By Zoom. Okay.
Both of those dates work for you?
Yes,
Yes, sir.
Your Honor.
All right. I'm thinking so. I think that this joint notice filing requirement, 14 days before trial, it could very well be useful to all of us. So I want you to build that into your pretrial order. Understanding that you've already got a pretrial conference.
You want that 14 days before the pretrial conference instead of 14 days out from trial?
Not sure. What do you think?
We could compromise if you feel like that's too far out from the trial. Maybe.
I'm going to defer to both of y'all to talk about that and think about
Okay.
it. I want to make this a little easier than a little harder. I can tell you this, that I will not be making a jury panel sit in the hallway without enough places to sit while we labor over a motion in limine. That's not going to happen. So I want to be able to rule on a motion in limine, any motion in limine that you have at the pretrial conference. And of course, I obviously want you to confer beforehand to try to reach agreements to the extent you can, and let me make rulings on what you can't agree to at the pretrial hearing. And I'm not sure that has to appear anywhere in your docket control order, but just be aware that I don't intend to spend an hour messing with your pretrial motions on the day of trial. I'm going to be concerned about the jurors' excuses and then voir dire. And I'm going to do everything in my power to minimize the inconvenience to the jurors and their legs and backsides. Okay, let's move on to pretrial materials 14 days before trial.
Judge, can I interrupt for 1 second?
Would that be Amber?
Yes, sir. I don't see a demand for jury in this case yet.
Well, they've just waived it. It's going to be a bench trial.
I just wanted to bring that to your attention.
Okay.
I'm with me.
All right. I'm joking.
Welcome to try the case, Judge.
You better make up your mind and comply with the rules of civil procedure.
Yes, sir.
One of you. So let's talk about whether it's a good idea or not to lay these requirements on you about pretrial materials 14 days before trial, like an exhibit list.
You mean, is that doable?
Is it reasonable to require you to do that?
I've got no problem with it.
What was that, David?
I've got no problem with that whatsoever.
Yeah, I think we can do that.
What about the witness list?
Same thing. I think we should have a witness list, exhibit list. We decide on what's admitted or what's not, what you need to rule on. Depot cuts, objections to, testimony, things like that. That way we're not doing it,
Motion in limine,
emotionally.
jury charge, presuming one of us.
Correct.
Okay, so the objective, of course, in part is to avoid the clumsy, cumbersome, mind-stretching problem of lawyers parading up to the witness stand and going through the process of trying to get an exhibit admitted into evidence. We don't want to have to bore the jury with that. We want to get that taken care of to the extent possible by the pretrial hearing. So I really want to try to have all rulings on exhibits accomplished and have them admitted into evidence or not by that day, on that day.
Understood.
Okay, so what we're agreeing then that your pretrial order is going to include this pretrial material items.
The deadline 2 weeks out from trial. 14 days, I believe your honor said.
Right.
Right, we'll put that in the DCO.
Okay. All right. What else would you like to take up this morning?
I don't think we have anything else.
I think that-
David, to you.
No. I don't believe there's anything else that we need the court's assistance with.
All right. I appreciate the candor on the part of both of you. And I look forward to working with you as you go forward. I can tell you that I'm very available, unlike elected trial court judges that they're bombarded with this sort of thing all day long. I have more available time. So if a problem arises in the processing of your case, the preparing of your case, that you can't get resolved by agreement, then I invite you to ask for help sooner rather than later, because I intend to try this case on July 31st if you haven't settled it. And you're going to be hard pressed to get a continuance out of me.
Understood.
Okay. Go in peace and have a happy holiday.
You too.
Thank
Judge.
you, your honor. Appreciate your time.
Absolutely.